who pays for college, and how do we handle student loans? Every parent is eventually going to run into these questions, but it can be especially stressful for parents who are getting ready to or already have gone through a divorce. Hi there, I'm Jenny Bradley, owner of Triangle Smart Divorce in Cary, North Carolina. And with Duke and UNC to our left and NC State and ECU to our right, we are very familiar with college expenses being a big concern for our clients. Before meeting with us, many of our clients don't realize how many college decisions they can make during the separation process, no matter their child's current age. First off, it is important to note something about North Carolina law. Court-ordered child support does not extend into the college years. It ends when a child turns 18 or graduates high school, whichever comes later, only up until age 20. While parents are not obligated under North Carolina law to pay for tuition and expenses or to support their children in college, many of our clients want to give their children at least some, if not full, financial support during college. While there are many things to consider for parents in this situation, we think it's especially important for you to understand these 5. First, 529 accounts. 529 accounts, simply put, are tax-advantaged college savings accounts for your children. But if you go to court, these accounts are considered marital property, much like a bank account, and are typically split evenly between the parties. The court will not dictate that 529 funds be used for your child's college expenses. So, once the funds are divided, each party could use their half of the money any way they choose, with tax consequences, of course. If you go through mediation, or you reach an agreement outside of the court, you do not have to treat 529s as marital property, and you can put rules in place for how this money is used. You can agree to use the money only for your children's college expenses. You could have one parent keep the 529 account and manage it on their own. Or you could split it 50-50 with each parent contributing and managing the money as they see fit. When you make decisions outside of court, there are many more options on the table for how 529s are divided and eventually used. The second thing you need to know about is FAFSA, or the Free Application for Federal Student Aid. It's the form you fill out for financial aid for college. When children have divorced parents, they have to only report income of their custodial parent to FAFSA. Figuring out the custodial parent is simple. It's whoever the student lived with for the majority of the past 12 months. If the students split their time equally, the custodial parent is the one who provided the primary financial support. While the non-custodial parent can still contribute to college costs, their income and assets are not included in the calculations for federal aid. The only exception to this rule is if the divorced or separated parents still live in the same household. We have found that some kids qualify for needs-based aid even when the non-custodial parent makes a high income. It is important to think through who the custodial parent will be during the separation process if you have kids close to college age, as it could dramatically affect the amount of aid they get for college costs. The third thing, tax credits. If you pay college tuition for your child, you could be entitled to receive a tax credit subject to income restrictions. The rule here is that only one parent can claim a child as a dependent for tax purposes. This parent does not have to be the custodial parent listed on the FAFSA, or even the parent the child lives with the most. Who claims the child as a dependent can easily be worked out in a separation agreement so there's no fighting down the line. And whoever that parent is would get the tax credits if eligible. The fourth thing is student loans. If you took out a Parent Plus loan for your child before you were separated, these are going to be viewed as marital debt, which means the debt will likely be treated like any other marital debt. If, however, your child took out a loan in their own name, then that's the child's debt. The court cannot order either parent to pay the debt as it's not marital debt. However, if it is important to you to help your child with their loans, you can work these payments into the separation agreement, but you have to stay out of court to do that. And the fifth thing to consider is limiting the payments. In a private agreement, each parent can put restrictions around their payments for college. Common limits we have put in place include requiring the child to have a certain GPA, to take a certain amount of credit hours, to finish in 4 years, only to go to public in-state schools, or really anything you think of. It can be addressed if it's agreed to. When there are no conditions and only an agreement that parents are going to split the cost, we have seen quite a few problems arise once children actually reach college. We are a fan of making smart rules about what a child needs to do to keep the benefit of a free education. We believe it helps teach accountability and personal responsibility. In the end, we find most parents don't want to punish their child for the fact that they're not together anymore. And if covering some or all of college costs for your children was an important part of your family's plan before you separated, then you should negotiate to keep that plan intact if at all possible. Give us a call if you need someone with experience to help you figure out ways to address college expenses. Here at Triangle Smart Divorce, we guarantee everything in your separation agreement is thought through, that all the I's are dotted and all the T's are crossed. We're here to make sure your family is taken care of, not just during the divorce process, but in the future.